Hi, my name is Anthony Bustani. In this presentation, I will be talking about the retirement villages in general, and more specifically about the difference between a lease agreement and a license agreement. What is a retirement village? Retirement villages are age-specific communities where independent men and women older than 55 live active, varied, comfortable life in the knowledge that they can age very well in a very supportive, safe, and secure environment. Retirement villages are regulated under state and territory legislations, and there are different types of accommodations within the retirement villages. It can be single villa unit, couple of stories, or it can be an apartment. The resident doesn't own the village, but he will be leasing it in some forms. In Australia, around 150,000 people are living in 2,000 retirement villages across the country. 40% of those villages are operated by non-profit groups, such as churches and charities, and the other 60% are operated by private people, such as developers like Stockland and Lendlease. The first requirement for entering a retirement village is that at least the resident or his partner must be age 55 or older. The second requirement is that the resident needs to be able to live independently in order to look after himself without the need for special assistance and high level of medical care when he joins. Now I will be talking about payment structure and some technical words in order to simplify the comparison between the two agreements. First, we have the incoming fees or entry fees. This is what the resident pays to the operator when he enters the village through a lump sum payment usually, or it could be through weekly or monthly payments. Secondly, we have the ongoing fees. They are paid regularly, weekly, fortnightly or monthly, for providing services, maintenance and operating the village. It's a price that the resident pay for living in the village, such as security, lawn mowing or pool cleaning. According to Australian legislation, it's a cost recovery basis, so operators cannot make a profit out of that. Thirdly, the outgoing fees are when the resident get part of the entry payment fees back once the unit is resold. And lastly, we have the exit fees or deferred management fees. Deferred management fee is the most important term in the contracts. It must be discussed and agreed between the operator and the resident when he enters the village. As a simple mathematical formula, exit fees is equal to ingoing contribution less outgoing payment. It's a fee that the operator gets paid when the resident is moving out the village. DMF is a percentage amount of ingoing contribution fees or outgoing fees multiplied by the number of years that the resident has been in there, and that's usually capped at a number of years according to initial agreement. In this example, the table shows the difference between the exit entitlement for the resident and the exit fees for the operator. The entry price agreed between the two parties is 700,000 and the DMF is 5% per annum. For the first year, DMF is equal to 5% out of 700,000. In year 4, DMF is equal to 5% times 4 years, which is equal to 20% out of 700,000. The capped here is on year 5, hence we see in the last two columns, DMF is equal to 25% and doesn't increase anymore no matter how long the resident lives there. According to Retirement Village Act 1999 in New South Wales, we have different types of contract agreements. The two main types of agreement in Australia are leasehold agreement and license agreement. Leasehold agreement, or it could be called long-term agreement. This agreement applies when the village is owned by for-profit operator, private companies, for usually 49 or 99 years. It's a registered interest, so the residents have an interest in the actual land. Therefore, they have an entitlement to the capital gain that will be in the original agreement between the resident and the operator. The leasehold is registered by the operator on the title with land registry services. The resident usually pays the entry fees through a lump sum payment, and the entry payment will most likely vary under market condition, which is similar to when buying a house. Moreover, the leasehold agreement has a very stronger security than any other agreement. A resident is considered a registered interest holder if all the following three conditions apply to him. First, the leasehold agreement must be registered with LPI. Secondly, the agreement between the two parties must be over 50 years. And lastly, the resident is entitled to more than 50% capital gain in the agreement. Overall, the registered interest holder has more responsibilities to the premises and has to pay additional legal costs and fees. Now I will talk about the license agreement. It's an unregistered license, and this license applies when the village is owned by not-for-profit operators like churches and charities. It's a license for the resident to occupy the village, and the resident doesn't have interest in the land. The license agreement model does not give the new resident the security of a title, and he is not a registered interest holder. Therefore, the resident is not eligible for a capital gain, but the operator can achieve it. If the contract is a loan or license to occupy, the contract may refer to the initial fees as ingoing contribution, an interest-free loan, or a refundable deposit in exchange for the resident right to live there. These fees are usually upfront costs, but most are refunded in part when the resident leaves the village. In conclusion, the license agreement applies to not-for-profit villages, whereas the leasehold agreement applies to for-profit villages. Secondly, the resident is entitled to capital gain in leasehold agreement if he is a registered interest holder, but not entitled to that gain in license agreement. Moreover, the leasehold agreement is registered on land title. However, that's not the case in license agreement. In addition, the entry payments usually are made through lump sum payments in leasehold, when in fact they are interest-free loan in license agreements. Finally, the contract has more security in leasehold agreement, but more flexibility in license agreement.